A revocable trust does not keep you from having to pay off debts that you owe to creditors when you pass away. Even though a revocable trust makes your assets avoid the probate process, you still have to pay off debts that you owe. So in this video, we're going to talk about what your backup trustee has to do when you pass away, and then we're going to talk about how you can set up asset protection from creditors so you don't have to pay those debts off when you pass away. And so while you're alive and you put your assets inside of a revocable trust, you can be the trustee and have full control over the assets inside of that trust. With a revocable trust, you are still filing those assets on your personal tax return, and that is why you do not have asset protection from creditors when you pass away, and you still have to pay those debts off. And then when you pass away, your backup trustee or your successor trustee will step into your role as trustee and take over the management of the assets inside that trust. It's going to be their responsibility to pay off the debts that you owe, manage the assets inside the trust, and then distribute those assets out to the beneficiaries per the instructions inside that trust document. So the first thing that they need to do when you pass away is grab your death certificate and the original trust document. This will show any institutions that you have passed away and that they actually have the authority to manage the assets inside the revocable trust. This is really important for real estate or financial institutions. For real estate, they have to take over the mortgage payments, the insurance, and the other expenses related to that property. For your financial accounts, they have to go to those institutions and have that money transferred into the trust bank account. At the same time, they have to publicly notify creditors that you have passed away. As an example, in Georgia, you have to do a notification in the local newspaper once a week for a 4-week period. And then creditors have a certain window of time that they have to respond to that public notification. As an example, in Georgia, they have a 3-month window to let the trustee know that there are debts that need to be paid off. And then the trustee will have to use trust assets to pay off debts that are owed to those creditors. Typically, what's going to happen is they will use liquid assets and then use physical assets. Liquid assets will be things like your financial accounts, checking, savings, investment accounts, etc. And then if there's not enough liquid assets to pay off the debts that are owed to those creditors, they will move on to physical assets. Physical assets will be things like cars, boats, or your house. And so what they'll have to do is sell those assets to generate money from the proceeds of that sale, take that money, and then pay off the remaining debts. Now, if there's not enough money inside the revocable trust to pay off all of those debts, then it'll wipe out all of the assets inside your revocable trust, leaving your beneficiaries with nothing, and your revocable trust will have been set up for nothing. Now, let's say that there are enough assets to pay off the debts that they owe. Any remaining assets would be distributed out to the beneficiaries per the instructions inside of that trust document. So some of the ways that the trustee can distribute assets out to the beneficiaries is going to be a lump sum distribution out to them, conditional based distributions where it's age-based or event-based, or it will be need-based distributions for things like education or healthcare. Or they can just reinvest that money on behalf of the beneficiaries and let them live off the distributions but not allow them to touch the principal of those investments. The trustee will need to have the beneficiaries sign receipts that they have received the assets when they make distributions out to them. That way they have the accounting accounted for and they are covering themselves in the event that the beneficiaries have any issues down the road. Now that we know what to do when the grantor passes away, how to pay off debts, and how to distribute the assets out to the beneficiaries, let's talk about how to set it up so that you don't have to pay off creditors when you pass away, because your assets have asset protection. If you're using a trust, you can put them inside of an irrevocable trust. The irrevocable trust will fully separate those assets from you as an individual. Now remember, with the revocable trust, you are still filing those assets on your personal tax returns, and that's why you don't have asset protection from creditors coming after you when you pass away. But with the irrevocable trust, you are fully separating those assets from yourself as an individual. You cannot be the trustee, you cannot be the beneficiary, and you're filing those assets on the trust tax return. You are no longer filing them on your personal tax returns. Therefore, you're fully separating those assets from yourself and your estate. And that's what gives you the asset protection. Now, the problem that most people have with an irrevocable trust is you don't have any control or benefits over the assets inside the irrevocable trust because you can't be the trustee or the beneficiary. Now, as an example, a trustee would be the person that would sell a house inside of an irrevocable trust. The beneficiary would be the person that would be able to take distributions from the proceeds of that sale. If you want help setting up asset protection so that your assets will avoid the probate process and have asset protection from creditors coming after them when you pass away, click the link in the bio, fill out the form, and schedule a time to talk to some on our team.